All right, welcome everyone to the input of child parent. What does it really mean? I'm very excited to introduce WEG-Weinfeld and Paula Rosenstock. I'm going to turn things over to them and allow them to get us started here this morning.
Great. All right, let me share my screen. Everyone give me a moment. Actually, let's see. Let me just queue it up so it's totally ready to go. Okay. Sorry. All right, can everyone, Rich, can you see that? I can't ask if
Yeah,
everyone
that's
can see
fine.
it.
That's very good.
Okay. All right, so yeah, let's get started. Welcome everyone. Some just our contact information here, our websites. There is, as we're going there, I understand there's a Q&A in the chat. So feel free to put questions in there if you have any, and we can probably address them at the end, but we'll see. It's probably the easier way to do it. All right. So today we are talking about the special education process, the IEP process, and how parents are to be partners in that process. We have our howdy partner here sign. And I think we hear a lot, and I guess I should back up and say that my name is Paula Rosenstock. I am a special education attorney working in the DC area, represent families in DC, Maryland, and Virginia. Yeah, those three jurisdictions. And my office, all we do is special education law, and we help families from sort of the beginning of the process. So, families who come to us and say, I think my child might have a learning disability or something's not going right. And we help them all the way through IEP process, due process appeals, which is when parents challenge the school system's decisions, up through court. So that's just a little bit of background about me. And Rich, do you want to introduce yourself now before we get started? I guess we should do that.
Just briefly, I'm Rich Weinfeld. I spent 30 years working in Montgomery County Public Schools, and after leaving that career, I started work as an advocate and soon founded Weinfeld Education Group, commonly known as WEG. And we've been in existence now almost 20 years, and we serve clients all over Maryland, DC, Virginia, and now virtually throughout the United States. And we help also at every stage of the special education process, also 504 process. Occasionally, we'll work as expert witnesses in conjunction with Paula and the folks at Michael Iges Group Law for Children. So very glad to be here today to talk about this important topic.
All right. So, going the wrong way here. Okay, so as I started off saying, we hear, I think, both as attorneys and educational consultants in the field, that parents are supposed to be equal partners in the process, the special education process, but it doesn't always feel that way. And what we have here, just summarizing that there really are, I think, a lot of limitations to parents being equal in the IEP process. And what does it mean, and how do you find ways to get over that and make yourself an equal partner? These are some things I think that parents often hear. There's some examples. One thing that we use a lot of different acronyms in the world of special education, and I think as you get used to it, they start to make sense. But when you're new, I think it can be completely overwhelming for parents. So here we have a few, what is a BIP, a plop, a PLAF? And one thing I find is from jurisdiction to jurisdiction, sometimes it changes. So even when I've figured it out, this recently happened to me. I heard a brand new one in a different jurisdiction. I had no idea what they were talking about because they called it something different. I think it was a different name for the PLOP, which is the present level of performance. You know, I think parents often get this reputation of when they are outspoken, they're a pain, you know, and it's okay to be a pain in the neck, by the way. That's how you advocate for your child. But I think parents can be really hesitant. They don't want to upset the teacher. They don't want to upset the school. They want to make sure that they're seen as being cooperative. And when you start to advocate, sometimes it can feel like you are being a pain in the neck. Another thing we hear so often is that, my goodness, I walked into the meeting or I logged on to the meeting these days and it was me and 15 people, or, you know, and it's overwhelming when you are sort of the only one on your quote team. And there are all these school system professionals and they know all the terms and they know, they've been to hundreds of meetings and maybe you've only been to one. And that can really hinder you feeling like you're a partner when you're completely overwhelmed by just maybe the sheer number of people. And of course, often I think parents feel like they're not being heard. You know, they're trying to advocate and the team isn't listening, is being dismissive. And really just have the attitude that parents don't understand that we're a school system and we know best, or we're a school team and we know best. And they're really, parents feel like they're being dismissed. So really empowering parents is so important through this process. And, you know, it's not just at the IEP table. It's throughout your child's education, you know, making sure that you have communication daily or weekly so that you are able to monitor your child's progress and advocate as necessary. And I think it's, of course, so true that when parents and the school system professionals work together, that makes parents feel more empowered because they feel heard and they feel like their input really matters. And in order to do that, it's really about building that supportive relationship between the parents and the school staff. Because at the end of the day, it's all about meeting the needs of the student. And if folks aren't working together, that's never going to happen. I've seen far too many times where, you know, the breakdown in the relationship between the school and the parent, and it becomes so toxic, and then it starts impacting the child. Not necessarily because, you know, I think sometimes parents are afraid, well, teacher's going to be mad and take it out on my child. And I don't think that's necessarily happening so much. But what it is a breakdown in communication. And so if a parent doesn't feel like they can email the school or communicate with the teacher, then it's going to impact your child. So the importance of parental participation. The law that we work under, the special education law, is called the Individuals with Disabilities Education Act. And it really does establish the importance of parental participation, which is really important, I think, for everyone to know and recognize. What we have here is some language from the law, and a little bit of background I think is helpful in understanding this. There are two different violations under the special education law, the IDEA. There are substantive violations and procedural violations. And a substantive violation is something like there not being the right goals in the IEP. So a parent might bring a claim under the IDEA and say, you didn't provide, school system, you didn't provide any reading goals for my child, or there aren't enough hours of special education for my child. Those are substantive violations or claims under the IDEA. The law also recognizes procedural violations. Those are things like timelines, and parents hear a lot about the different timelines in the law. Has the school system complied with, you know, school said it was going to evaluate my child, and it's supposed to have 60 days, 90 days, depending, and it's been 5 months. Well, that's a procedural violation of the IDEA. And most procedural violations of the IDEA only rise to what we say a denial of FAPE, a denial of a free appropriate public education, if they impeded the child's right to a free appropriate public education. Did they have an impact? So let's take, for example, that timeline violation. If a parent can show that by failing to comply with the timelines, the child didn't get evaluated in time and missed out on services, we might see a violation that rises to a denial of FAPE. There are other procedural violations that don't actually cause a denial of FAPE, and a court wouldn't recognize them as such. And the reason this is important is what the law says with regard to parental participation is if a procedural violation significantly impedes the parent's opportunity to participate in the decision-making process regarding the provision of a free appropriate public education, it rises to a denial of FAPE. What this means is there doesn't have to necessarily be that impact on the child directly. The law recognizes that parental input is so important that a violation that impacts a parent's ability to participate in the process is a standalone violation of the IDEA. So that's pretty powerful. And there is some discussion in the case law about what is the decision-making process and what does it mean to impact on that. And we'll talk a little bit more about that later in the presentation when we talk about things like predetermination. But I think it can be helpful to see the language of the law, and that's the citation right there. The Supreme Court, the highest court in our land, has also emphasized the importance of parental participation. And the first case I have cited here, this is a case from 1982, it's the Rowley case. And you can see the language here that this is actually talking about the importance of those procedural safeguards that I just talked about. And this is the Supreme Court saying, the procedural safeguards of the law, such as that parental participation guarantee, are just as important as the substantive pieces. And it's recognizing the importance that Congress attached to it. The next quote here, this is the Andrew F. case, and you may have heard of it before. This is a 2017 case from the Supreme Court that has had a lot of really wonderful impact. It has some great language for parents overall for special education. But what the court said here is that the fact-intensive exercise of determining whether a student's IEP is appropriately challenging and ambitious, it depends not just on the opinions of school officials, but also the input of the child's parent or guardians. And that's really powerful language because that's the Supreme Court, again, the highest court in our land, recognizing the importance that parents play in the development of special education programming for their child. All right, I am going to, with that, we've set up sort of what the law says about parental participation. I'm going to turn it over now to Rich to talk a little bit about how this works throughout the IEP process, before and after also.
Thank you, Paul. And Paul, we can hear one of your loud partners in the background.
Yeah, I'm going to go ask him to keep it down.
Okay.
Give me one moment.
Thank you. I know he's just doing his job. It's wonderful to have these legal decisions and to have clear guidance from the law about the importance of parental participation. And honestly, I'm in my 50th year of doing this, and we've been talking about the importance of parents' input probably the whole 50 years. But the question is, how do we do it? And how do we provide vehicles for parents so they can really have meaningful input? How can we make sure that during the meetings, their voice is really heard and listened to? So that's what we want to give some advice on, some tips on today. So Paula, we can go to the next, there we go. So the most important part of the IEP in our opinion as advocates, and I think the attorneys would agree, are the present levels of the IEP. This is where we describe how a student is functioning in math, reading, writing, but not only the academics, we also describe how they're doing with their behavior, their social skills, their executive functioning. And what goes into these parts forms what we call the foundation of the IEP. If we know that a student has challenges in their social skills as described in the present level, then we know we need to have goals that relate to that. We need to have accommodations that relate to that. Ultimately, we have to have special education instruction or services that relate to that. And this could even drive placement, whether it's different classes within the homeschool or a program outside of the homeschool, even a non-public placement. So getting the present levels right is crucial. And this is the first place where the parent perspective must be included. So before we go into an IEP meeting, whether it's an advocate with parents or parents on their own, it's really important for parents to give input about how do they see their child functioning in all the academics and all the functional levels. And parents can share that perspective based on what they see at home. Well, how the student is functioning when they do their homework, how the student is feeling about what happens during the day, what they talk about, whether they're unwilling to go to school. All of that input is extremely important and then feeds into the present levels. Parents should also provide information from any private providers that may be involved with the child. And this includes really everyone that is involved outside of school. Could include tutors, could include therapists, could also include non-academic activities such as sports or music classes or art classes, because that can be both good information about how the student does at their best, and it also may also provide some information about student has trouble paying attention, even involved in an activity that they really like, or has trouble working with others on their sports team or in their club. So very important information. So I always tell parents, provide all the documentation that you can about how this child is functioning, not only in school, but also outside of school. And then based on all this information, this may drive new assessments. We may never have thought, oh, this child may have a social skills issue. So let's look at that through the lens of an assessment. Let's get updates about what we know about the child with social skills. Let's ask their teachers more about it, because we're seeing this at home with the tutor, with the therapist, with the coach. So let's find out more about what the teachers are seeing about this. So that drives the present levels as well. And often we will look at the present levels that are developed by the school and give our input, but another option is to create our own present levels and give them to the school. And one thing that we've been able to do with those present levels is we can actually visually show how the student is functioning on a chart or a bell curve. So to chart the IQ scores, which may be average or above average, and then to chart some of the academic scores, which may be below average, and to see that visually, where the strengths are, where the weaknesses are, can be very very profound for everyone involved, and really bring home the fact that we have a student who's capable but is struggling in some of the areas. In order to truly be a partner in the IEP process, parents need to thoroughly review all documents that will be reviewed at the meeting prior to the meeting. Unfortunately, in Maryland and in DC, the law is on parents' side in relation to this. And it wasn't always the case, but in recent years, parents are required to get the documents. I know in Maryland, it's 5 days in advance. Paula, is it DC, is that also 5 days in advance?
That's right. Maryland and in DC are 5 days. Virginia, there's unfortunately no rule or protection on that.
So not a legal protection in Virginia, but even in Virginia, we would want to ask the school, please provide the documents before the meeting so that we can review them and really be ready to be a partner in the meeting. So there's a little more information.
Yeah.
There are some other states that also require school systems to provide documents. California is one. Most states do not have a legal requirement, but again, even where there's not a legal requirement, we should be requesting the documents in advance.
In most states, I think, especially like I see it in Virginia, they still recognize that it's important and helpful, so they often will go ahead and comply with that. But you know, when we don't get them in advance, if we really need them, we'll use it to cancel a meeting and ask for more time, because it is, you know, it used to be, and Rich, you probably remember, we would sit down at meetings and they would hand us a stack of documents, and there you are trying to, you know, read a report while the team is talking, and it didn't allow for equal participation at all.
I agree with that, and and it is a judgment call. If you don't get the documents in advance, you know, sometimes you want to take a half hour to review them and then go ahead with the meeting. Sometimes you do want to, as Paula said, postpone the meeting. Again, just in the interest of being a true equal partner in the process. So when schools prepare a draft IEP, it's very important for parents to go through that IEP and look carefully about what's being proposed. And the IEP should, of course, be based on progress the student has made in the past year, where the student's deficits still may lie. So when the schools are providing this IEP, you not only want to see the IEP itself, but what was the data that led to the development of the IEP? What was the testing? Have parents seen all of that testing? What were the work samples that was based on? And you know, let's actually see what is the student doing in the class. Let me pause a second on work samples. Often what the work samples we see are a finished product. They're the final draft that the student has developed after working with the teachers and going through many steps. And that's fine to see. It's good information, but it's also good information to see what does the student's first attempt look like. And often parents have those work samples at their disposal because they see what students do at home. So parents, when a student is working at home, save a copy or take a picture of it so that you can add the work samples to the meeting and share them with the team. And again, this is not a gotcha, you know, kind of thing where you say it's good and we say it's not. It's let's look at all the data together. Let's be collaborative. Let's be fair, and let's honestly see where the student lies in terms of their strengths and weaknesses. We're going to review the teacher reports that led up to the IEP. So how is the student doing with each of the teachers? And we really want to make sure we have reports from all of the teachers. We want to make sure they're thorough. They provide information about both strengths and concerns. Attendance is very important. And attendance is an interesting issue, and I'll ask Paula to comment on this as well. There was a time in my 50 years where people would say, well, you know, if they're not here, what can we do? You know, it's not our fault they're not here, and we can only deal with the student when they're in school. I think we've really moved much more towards a state of mind, which is non-attendance is often an indication of a problem. So the student being anxious about attending school, the student having trouble when they're in school. So that's that data in and of itself. I don't know, Paula, if you want to comment on that.
Yeah, I mean, and this has been a little bit of a side passion for me because I've seen such a rise in school, you know, anxiety leading to attendance issues. And I think, like Rich said, for a long time, the schools, I would hear it, you know, attendance is not our problem. And I think there's now a level of acceptance, especially in the DMV, that non-attendance is a sign of something else going on. And, you know, that in and of itself can even lead to a child being found eligible for special education. And here in Montgomery County, we have some programs that are developed that actually do target that school attendance. So I'm not afraid, for example, to say to a team, you know, give me the attendance reports. And if the child's not attending, we need to write a goal for school attendance. And then sometimes we get into an argument about it. But yeah, I think attendance reports are critical. So definitely ask for them as part of the process.
And I'll just make a quick tangentially related comment. The creator of the high school programs in Montgomery County for students who are school avoidant, highly anxious, often depressed, was Dr. Kristen Eccleston, who I'm now proud to say is the Director of Social Emotional Services at WEG, and she's behind the scenes hosting this webinar. So behavioral data, that's another piece of documentation that supports what is in the IEP. And again, parents want to examine the actual behavioral data to see what it includes. Is it comprehensive? Does it really get at all the information that we need, or do we need more or different? And that's fine if we do. Again, I want to emphasize that this is all part of a collaborative effort. It's not adversarial. It's the idea is we and the school, all of us together, need accurate, thorough, comprehensive, current information about the student. So let's all make sure that we have that. So how can the special education consultants help parents to make sure that they have true, complete partnership and input? One thing that we do at WEG, and I think most other consultants or advocates, and those are names for usually the same group of folks. Most consultants or advocates will prepare something that we at WEG call a reactions document. It might have different names, but what it is a thorough review of the IEP with notes about what is missing in the opinion of the advocate and the parent, or additional information that the school team should have about the pages of the IEP in question, or disagreements about what is there and requests for it to be removed or changed. And we can go ahead to the next bullets. We like to give these reactions to the school in advance, so that the school knows what we're coming in to talk about, knows our questions, and this can actually be very important in the conduct of the IEP meeting. And I think we'll talk more about that in a few minutes. Consultants typically observe the student, and I'll say that this is an extremely important part of consultants forming an expert opinion. We of course review records, we of course speak to the parent, we speak to everyone involved with the student, both inside and outside the school, but it's very important for us to see the student ourselves, see what's happening in the school environment, and then write up a report that details what we saw and also includes a summary of the strengths and challenges that we saw of the student. And often we make some recommendations, either for things that might be in the IEP, new accommodations, new goals, sometimes for different programming for the student than currently exists. And parents, we always run our recommendations by the parents for their input and their approval. And then we ask to make sure that the parents submit that document, that reactions document, and that observation report to the school in advance of the meeting. So just as we, to be equal partners, want to see all the documentation, of course, the schools want to see that as well. Now, I don't believe, Paula, there's a legal requirement for parents to give that documentation in advance, but it certainly is best practice. And if we're going to be collaborative and non-adversarial, it's something we would want to do.
Yeah, sometimes parents do hear back from the school that school will try and flip that 5-day rule and say, well, you have to give us everything 5 days in advance. And the law doesn't work both ways. It's only the school system's responsibility. But Rich, I think to your point, to be collaborative and respectful, if you can submit it in advance, I think it's really helpful for the team. These teams are busy, and it'll make a more productive meeting. The other thing I just wanted to add is I think sometimes parents have this feeling that, I don't want to have to do all the work for the IEP team. It should be the IEP team's job, not, I shouldn't have to be doing it myself or paying a consultant. And shouldn't we let sort of the IEP team make the mistakes, and won't that make a better case? We hear these things sometimes. The first point, yes, it is the team's responsibility. And unfortunately, they're not always doing what they need to do. That's why the law exists. That's why, Rich and I do what we do. And so unfortunately, sometimes that is necessary. But on the second point, it's been our experience that if you don't raise these things at the IEP level, if you then get down the road to a due process hearing, it doesn't present well in front of a judge to say, oh, I knew that there needed to be goals in reading, but I didn't say anything because I thought the team should just know that. The hearing officers or the administrative law judges give a lot of weight and deference to school systems. And if you don't come forward and say it when you know it, it'll come back to bite you. So better off telling them at the meeting, bringing your consultant and making a record at that time.
And I'll take that another step to say that, today's topic is making sure parents are heard and are equal partners. And if we're holding things back or not sharing things, then we can't really expect that equal partnership. The goal is to be collaborative, is to be true partners, and we can only do that by being transparent. And the other thing is that, Paula and I and, Michael Ige's entire group, Law for Children, and WEG folks do work together at times, but we settle, I shouldn't even use the word settle. We work productively with IEP teams to get students what they truly need without legal remedies the vast majority of the time. It's only when things don't work, when the kids are not getting what they need, when the collaborative process breaks down, that's the only time when we're going into a hearing. So the goal is not to have the best hearing, the goal is to give the child what they need. Paul, if we could go back 1 second, I just wanted to hit on the last bullet on the last page. So reactions document serves important purpose before, during, and after the meeting. So again, the reactions document is where we have made notes about the IEP, what we believe should be changed, what we think is missing, things that we're requesting. Often when we come into the school meeting, especially when school teams are used to working with us, we'll say, hey, we agree with a large part of the IEP. We've reviewed it thoroughly. We really don't need to go line by line through the IEP. Let's just focus on these areas where we had concerns or input that we felt was missing. School teams almost always agree to that. It makes for a more efficient, quicker meeting, a really focused meeting. So the reactions document can really drive the actual agenda of the meeting. And then after the meeting, we've actually taken notes throughout the meeting on what was the school's reaction to the things we asked for. Some of the things they said, yes, sure, we can make that change. We're glad to do it. Some things we've compromised on and said, okay, well, maybe it doesn't have to be this. We'll move a little bit towards what you said. Some things we maybe have dropped when we heard the school's explanation for it and it made sense. So we've taken those notes, and now we know, first of all, we have a record of what happened in the meeting, and now we know what to look for in the final draft of the IEP and the prior written notice to make sure that they're also in line with what our notes say happened at the meeting.
Yeah, I'll say the reactions document, I think, has been so, I think you guys have come up with it over time. It used to be we took notes and then you turn your notes. I think you really perfected it, and it serves a lot of great purposes.
Thank you. Thank you.
All right.
Okay. So during the IEP meeting itself, if parents are going to be true partners in this meeting, they need to understand what is happening in the meeting. And that kind of goes without saying, but there's a lot of technicalities, there's a lot of jargon. What happens in the meeting is driven by previous law cases that have shaped, what schools need to do and what they should and shouldn't do. So it's not an easy process for parents to understand all the language in and every step of. So parents, if you're on your own, stop the team, ask questions, make sure you understand everything that's being said. If you're with an advocate, then that is part of the advocate's job to say, okay, hold on a second, please. You just used FBA, and parents may not know what an FBA stands for. So parents, do you know functional behavior analysis? Let me talk about what that is and why the school is suggesting that. So the meeting needs to be very much on the parents' understanding level. Otherwise, there's no way they can truly be a partner. So again, we emphasize parents providing input before the meeting. So now we're at the meeting. We have the IEP document in front of us. Sometimes the school team has taken that input and already made changes to the IEP where they can accept what the parent asked for. So this is a time to make sure that that IEP is really updated as the parents asked for. And again, take the time to see that it's really what parents and consultant felt should be in the IEP. Don't just accept, yes, we took your information and we've done that. It's not that we're again, not that we're adversarial or we don't trust the people, but it's in any human communication, we just want to make sure the communication was received as we intended it, and they've really utilized our input. And if not, then it's a discussion. Maybe there's good reason they didn't word it the way we asked to. Maybe we will ultimately agree with that, but let's take the time to discuss it. And then parents and consultant will advocate for goals and objectives that are understandable and measurable and will demonstrate progress when achieved. And parents should be able to read the goals in the IEP and any objectives that are under the goals, and it should be meaningful to them. Parents should be able to know that, okay, I will be able to see by the end of this IEP, usually a year from now, I'll be able to know whether my child achieved this goal or not. And if you can't, as a parent, say that you understand what the child's going to have to do to achieve the goal, it's not a good goal. So if the goal just says the child will be able to do blah blah blah, how will we know that? It's got to be spelled out exactly what the behavior or academic skill will be in a year, so that we will know the child has achieved the goal. So parents, oops. Yeah, so we're on to the next.
Okay.
So beyond the goals, and I will say one more thing about the goal, is that every goal has what the child will be able to do. It also has the conditions that the school will be giving the child in order to meet the goal. So given a graphic organizer and specific instruction on how to write an essay, the child will write a 5-paragraph essay. It's not enough to just say the child will write the essay, because if the child could do that, we wouldn't have a goal. So what's going to be different? What's going to be new so this child can achieve this new skill? And then what was the criteria that we're going to look for? 80% on a teacher rubric, that would be reasonable. 80% performance on a test, that might be reasonable. But we have to make sure the criteria aligns with what the goal is and what we're hoping to see the child do. Just to put 80% on every goal, which is typical, may or may not be meaningful. So again, parents should ask, 80% of what? How are we going to how are we going to see this 80%? Is it going to come home as test results, as an observation checklist, as work samples? What are we actually going to see that's going to demonstrate the goal? And that becomes very important as we chart the child's progress. So now on to supplementary aids. This is where we talk about the accommodations, the things that are going to be used in the classroom, things that are going to be done outside of the classroom to help make sure the child has access to their educational program. And for meaningful parental participation, an important supplementary aid can be regular communication between home and school. And we often ask for this to be as often as once a week, sometimes once every 2 weeks, sometimes more than once a week for students who really have significant problems. But so by writing this into the IEP and supplementary aids, parents can expect to see regular progress from the teachers, from other folks in the school who work with the child to see how the child is progressing. During the meeting, there are going to be things that the school team may not agree with, and the parents may not be willing to compromise on, or may not be willing to let go of, because they believe it's truly important for the child, and it's not a place where compromise can be made or this can be dropped. When that happens, and we've had a good, thorough, amicable, hopefully, discussion about this, then we reach a point where we can see that the school and parents are not agreeing, and then parents or advocate or attorney, if they're there, would say, please make sure to note that disagreement in the prior written notice. And so that becomes part of the record of the meeting. That becomes potentially important later on when we go back and look at a history of what happened in the different meetings, that this was an area where the school and parents did not agree. Paula, anything about that you want to say?
Yeah, I would just note, Rich, that the reactions document, that if you're, if you have a consultant with you, they'd be doing it. And of course it would be noted there, but it's really important to ask that it be included in prior written notice or meeting notes, because those are the sort of quote unquote legal documents, especially that prior written notice, that makes a record of the meeting. And if we go back, or if there's any question as to what was discussed at the meeting, that's going to be our record. And we may get to this later on in the presentation, I think, but if you get a prior written notice and it doesn't capture what you think it should, based on the conversation at the meeting, you can ask for changes to be made, or supplement with a letter or something, because it's that important. And it's not meant to be a transcript of everything that occurred, but at least just a statement that reflects that there was a conversation and a disagreement.
And for folks who haven't been through an IEP before, prior written notice is probably the worst title for any document ever. It doesn't come prior to the meeting, it comes after the meeting, but I think it's prior because it's supposed to be prior to the school taking action. Is that right, Paula?
I think that's right, but I've never actually figured it out. But yeah, I think that's correct. It is confusing, but it does come after. Sometimes it's part of the IEP document itself, especially the new DC IEPs. It's actually included in the IEP document.
And I will say in Virginia, part of the standard practice is to read the prior written notice to the parents during the meeting, which I really like. Mm-hmm. That's not always done in Maryland and DC, but that's something that parents could ask for.
Yep.
Parents and their advocates should ask questions about the proposed special ed services so that they understand what the child's school day will look like. I can't tell you how many meetings, and I've been to with Paula and others, where we get a proposal. Okay, we're gonna have 3 hours of special education instruction per day. Okay, what will they be? What classes are we talking about? How will that be done? And if the team can't answer that, that's really a problem, because then parents do not know what's being proposed. They're, again, not a true partner in the process. So that question should be answered. What is my child's day going to look like? What When are they in general ed? When are they not in general ed? What subjects? For how long? Those are crucial questions.
And again, if the team won't tell you or can't tell you or you're not clear, ask that it be noted in that prior written notice.
It's very important for parents, and again, advocates can help them with that, to clearly state their position in the meeting. We disagree with this proposed placement because of the following reasons. Paul and I and others have been involved in cases where, it was clear parents and an advocate didn't agree, but we didn't specifically say, that we didn't agree and why we didn't agree. And we knew that everyone there knew it from everything that happened in the meeting, but it's very, very important to make a clear, specific statement. When the team does make, and this goes back to, I think, the first slides that we talked about looking at the draft IEP, but also during the IEP meeting, when the team is saying, oh, he's doing fine, his reading has really improved, oh gosh, I'm so proud of him. It's wonderful to hear those things, but based on what? Where's the data to support that? And again, it's not adversarial. It's not that we're saying, oh, we don't believe you, or you're not telling us the truth. It's that sounds great. Show us the data. Show us how we know that. Very important for parents. If you're alone and if you're with an advocate, then this would usually fall to the advocate. Take detailed notes about all that is agreed to and not agreed to during the IEP meeting. And again, we use that vehicle of the reactions document to do so. Again, I can't emphasize enough that this is a process that is not intrinsically friendly to parents. It's a difficult meeting to understand. Again, you're there with a table full of people who are professionals who do this every day. Hopefully you have somebody with you, an advocate or a relative or someone to support you, but you're clearly outnumbered, you're out of your depth, even if you are a very intelligent professional. And I can say I have been to an IEP meeting for one of my sons, and even though I was a special educator, it was a hard meeting because I was emotional. I was not objective. I didn't know whether I was asking for too much or too little. I didn't know whether, my view of how my son was progressing was accurate or not. So it's really important to try and level that playing field. One way to do it is to bring an advocate. But another thing, ask for breaks when you need them. Take time during the meeting to consult with your advocate or attorney. And you can do that in a couple different ways. These days, so many of our meetings are virtually, so we often open up a text chain during the meeting or email chain so that we can communicate as the meeting is going on. But sometimes parents may just need a time to conference with the advocate or with the attorney to understand what's going on, maybe to understand what the advocate is doing and saying that seems to be off course of what was agreed to. So just know you can always ask for a timeout. And there is time pressure during these meetings. Meetings are usually scheduled for an hour. Sometimes we have the abundance of being given 2 hours, but even with 2 hours, sometimes it's just not enough time to do it carefully, thoroughly, in a way that parents can understand. It's okay to go over time and either extend the time if people can do that, or there may be a meeting right behind you, which we understand. In that case, we have to reconvene and come back. And schools are very much driven by timelines, and they should be. There are legal timelines involved, and schools are monitored about that, and they really have to stick to those timelines. But the timeline isn't as important as parents understanding the process and being heard. So parents can give permission to extend the timeline? And Paula, maybe you can speak to the legalities of that.
Yeah, the schools are very concerned about timelines. They are monitored by the state to a certain extent. So, sometimes we'll ask, we want to reconvene. We know the IEP, maybe IEPs are annual. So once a year, the IEP is meant, it actually will quote unquote expire at the end of the annual review date, which should be on the IEP. Sometimes we just can't get ourselves together in time, or we start and we're not able to finish. And so we may enter into an agreement and say, look, the old IEP will remain in place so that we can break and we can reconvene at a later date to make sure that parents feel like they're part of the team. And sometimes it's not even, it could be something such as there's a new report coming and the parent feels it's going to be critical to have that report considered before the IEP is finalized. So that might be a reason that we agree to reconvene. And it's okay. I mean, you want to consult with, if you have a lawyer or your consultant, to extend timelines. Generally, that's okay in order to make sure that that IEP document is complete.
Okay, we can go on to the next page. So after the IEP meeting, we're going to receive documents from the school team. Paul, a legal time frame for that?
So in Maryland, they have 10 days, and in DC, I believe it's 5. I don't have it right in front of me, but and then again in Virginia, it's like anything goes. They don't have a set timeline, but I think teams are pretty good about sending them. Sometimes you have to remind them, send a quick email, I need my finalized documents, but they're pretty good about it.
Okay, and again, the advocates can help monitor that timeline. So it's very important. Now you've been through the IEP, maybe you felt great about it. It was a great meeting. Everybody was cordial and agreed to make the changes that were needed. It's still not over. We have to carefully look at the final IEP and make sure it does accurately reflect the decisions that were made in the meeting. Often on my reactions document, I'll have school agreed to make this change, and then I see the IEP and the change was not made, or was made partially. So that, and again, it doesn't mean it was mean-spirited or there was something bad happening on the end of the school. We're all human, and people hear different things, and may not thoroughly pick up on everything that's talked about. So this is another chance. If not everything is included or something is misrepresented, first of all, we update on the reactions document that this was not done, and then we let the school know. Remember, we agreed to change that reading goal to make sure that the student would be given an evidence-based intervention with fidelity, which is something we commonly ask for. I don't see that in the IEP, and hopefully the schools say, "Oh yes, I'm sorry, we'll correct that." If they don't correct it, again, we're gonna make note of that. We're going to state that that's a disagreement. So this is still part of the process of finalizing and noting all the disagreements. So now we finally have the IEP. It's done. Parents have been a good equal partner in the process, and now we're into monitoring the progress of the IEP. And again, parents are equal partners in this monitoring of progress. So at least as often as students receive report cards, parents will get progress reports on how the student is doing in each of the goal areas. Often the progress reports are pretty surface level in terms of, yes, they're making sufficient progress, is typically what we see for most goals. It becomes important then for us to say, that should be review raw data. It's not a new word. It's important for us to say, okay, you're saying he's making sufficient progress on that reading goal. We'd like to see the evidence of that. We agreed that the goal would be measured by 80% performance on weekly quizzes. I haven't seen those weekly quizzes. We'd like to see that. whatever the criteria were that the goal was to be measured on, hopefully, number one, we've written the goal in such a way that it produces documentation. That's why we want to make sure to know it's measurable and we really know how the goal is going to be achieved. So now we're in the period of, is it being achieved? We should be able to see that documentation. And then the consultant advocate can complete new observations to see how the child is progressing and create and submit new observation reports. And that kind of reinitiates the whole cycle of a child's doing much better in writing, but now we're seeing not as attentive as they used to be, more a problem with executive functioning skills. So let's make sure we're addressing that. And that can drive proposing and conducting new assessments when warranted. Schools are required to consider doing new assessments once every 3 years, and my language there is carefully stated. They're required to consider it, not required to do it. So we may ask, parents and advocate may ask for a new assessment based on some level of challenge we're seeing or questions that we need to have more information about. So I'm going to turn this back over to Paula for talking about the legalities of observations and some of the other legal information that relates to all that we've talked about.
All right. So observations, Rich mentioned it. They are really so important to the process. Parents, if they have opportunities, and we'll talk about in a minute the legality, or a consultant to see the student in their program, or if there's a new proposed program, asking to visit that proposed program. Having the consultants then write a report about the proposed program, what they saw, what they liked, what they didn't like. They're not guaranteed in the IDEA, but they are certainly encouraged. And we always encourage parents and consultants to make and document requests for observations. So let's talk about the legal requirements. Parents often ask us, do we have a legal right to observe? No, unfortunately. In general, there's no federal right in the law to observe either your child in a program, which feels really sort of like wrong, right? You're like, my kid's spending all day in this place. I don't have a right to observe. And no, you don't. There is, at the state level, there is some right. But the U.S. Department of Education has issued some guidance that they do encourage school districts and parents to work together to, in general, which is everything we're talking about, of course, but also to give parents opportunities to observe in their child's classrooms or proposed placements. So I think, it's great that the Department of Education has acknowledged the importance of this, because you really, you can talk a lot. The IEP is this big document. My goodness, I did an IEP yesterday in DC. They have a new system. It was 85 pages long. Had a lot of white space, but still, but there's nothing like seeing it in action. I think that's really gives you critical information. Some states do have laws that provide the right to observe. And we're going to talk a little bit about the DC right, because we are in the DMV. I don't know if we have any DC parents joining us, but also in Connecticut, there is a law that provides for a parent's right to observe. So
Paula,
the DC,
Paula, can I just
yeah,
interject
please.
from a advocate standpoint? I would say the vast majority of times schools do allow us to observe. They may send a staff member with us on the observation. They typically do that, and that's fine, because then we have the staff members seeing the same things we are. And in fact, we often converse with them during the observation, say, are you seeing, the child's having trouble paying attention or not able to write like the other children or whatever it is. When we have a building administrator who says we can't come in, I will typically reach out, well, first to the building administrator, but then to supervisors to say, look, we're trying to be collaborative. Parents have a right to equal participation. Without seeing what's happening in the class, they can't be equal partners. And often that will be enough to overcome the resistance.
Yeah, really good point. Sometimes it takes more than just one request, and really pointing out that you are trying to work together. As I mentioned, in DC, the DC code has provided, this was maybe 3 years ago, a legal right to observe. And what it says that upon request, the LEA, which is the local educational agency, which is typically DC, shall provide timely access. And it's not just for the parent. You can see here, it's for the parent or a designee appointed by the parent of a child with a disability who has professional experience in the area of special education, which would be somebody like Rich or an educational consultant that you're working with. Or it could potentially be an evaluator, and there's a variety of people that might fall in that category. And the purpose of this, the reason that DC has included it, and it was in something called the Student Rights Act initially, and then put into the DC code, is that they acknowledge, the DC law acknowledges that parents should have time to observe whether the proposed program is able to support their child, in their opinion, or whether it is supporting their child. So again, this is both the program your child might be in, but also, let's say the IEP team comes together and acknowledges that your child might need a specialized program. Well, in DC, you have the right to see that. There's also language that talks about the duration of the observation, and I just ran into this yesterday. A team said, okay, parent and consultant, you can come in for 30 minutes. And we pushed back and said, that's not enough time for us to sufficiently determine whether the program is supporting the child. So they gave us 10 extra minutes. So, it's something. The 40-minute observation is better than the 30-minute. But we are finding that even with this, there's some attempt to limit the observations, especially we see it in DC, particularly when we've filed a hearing request. So once a parent files a hearing request, it can be very challenging in all jurisdictions to get that observation done. And I think that's because there's a sense that you're just going in to gather data for your hearing. Sort of, they'll call it discovery. You're just trying to get information. Interestingly, there's some case law that suggests that there shouldn't be a limitation even once you file for hearing. What the case law talks about in DC is that parents should be on equal footing. There's this sort of acknowledgement that it's so unfair, both at the IEP level and at a hearing level, that the school officials, they see your child every single day. They're constantly gathering information. And you really, as a parent, don't ever have that opportunity in the school setting. And so the law does talk about, the case law, that parents should be on equal footing, and getting that information through an observation is a critical piece of that. So what should you do when you're denied meaningful participation? Well, we've already talked about that reactions document, asking for it to be in a prior written notice. Asking for a cogent and responsive explanation. You might think those are kind of weird words. Why would you pick those words? That's language right out of the Supreme Court. So that Andrew F. case I referenced in the beginning, the court talks about the fact that parents should receive and are entitled to a cogent and responsive explanation for why a team is doing what they're doing, particularly when a parent is asking for something different. So parent is saying, I really think my child needs a reading intervention, and the team is saying, no is not enough. Why? Tell me why. Why is it that you think my child can make progress? Give me a cogent and responsive explanation. Sometimes you'll get one. Usually you won't, but at least you're documenting it. And yes, document everything. And if it comes to it, consult an attorney for an appeal. And it can just be a consult. Sometimes we meet with people and we say, it's not going to be worth going through an appeal, or go talk to a consultant, see if you can work it out. But we're always happy in our office to talk to folks and help you decide, is it worth pursuing? I mentioned in the beginning something called predetermination, and I thought, It's an interesting topic to talk just a little bit more about. I'm being mindful of the time, so I'll go through these slides a little bit quickly so we can get to some questions. But predetermination has been long recognized as a procedural violation of the IDEA, meaning it impacts, and it can also be a substantive violation, but it impacts the parent's ability to have meaningful input into their child's education. What predetermination typically means is, for example, deciding where a student should be placed before the development of the IEP. And predetermination, by the way, is something a school system is guilty of. A parent, not so much. A parent can go into a meeting having a very clear view of what they think needs to happen, particularly if the child's already placed in maybe a private program. And it's not the same violation. It's the school system that needs to come into the meeting with somewhat of an open mind. These are some cases that have come out and that have some guidance as to predetermination. What some of the courts have said is just being at an IEP meeting is not sufficient. Like sometimes we'll see the defense of the school system will say, well, the parent was at the meeting, they were able to speak. That's not enough. They have to have meaningful participation. And so if you go to a meeting and you're asking for placement in the autism program in Montgomery County because you've heard it's a great program, and the school has already decided before they entered that room that no way, no how are they going to place your child in the autism program, that may rise to the level of predetermination. Just a little bit more about predetermination. School doesn't have to defer to every parental request. So just because they don't agree with you doesn't mean they've predetermined it. But they do have to have that open mind, be willing to engage in a conversation. The other thing that sometimes we hear from parents is, oh, the team had a pre-meeting. I know that the attorney met with the staff. That's okay. They can have pre-meetings. They can have even an idea of what they're going to discuss or propose. And parents who've been to a lot of meetings know that when you go to a meeting, typically the school's bringing representatives from some different programs, if in fact they're going to be considering placement. So they may have somebody like Dr. Eccleston, who when she worked for Montgomery County represented a certain type of program, and that's okay. In fact, it's to your benefit because it gives you the opportunity to ask questions about the different programs. So in conclusion, parental participation is a key procedural protection under the IDEA. And the way to really exercise that meaningful participation, we talked a lot about it, but submit documentation before, during, and after the meeting. Speak about, make your requests known, whether it impacts present levels, the goals. Don't be afraid to submit letters and reports from outside professionals. Keep in mind that just because your doctor says, you know, that your child requires a different placement, again, it doesn't always mean that's what the school is going to do, but it's important data that the team needs to consider. And keep in mind that advocates and attorneys can help ensure that parental participation and make sure that it's meaningful. You know, it's not always required, but when you're feeling overwhelmed, I think that it can be really helpful to bring along. And sometimes it can just be a friend or someone who's been through the process before. Don't go it alone. Make sure there's someone there to support you. Any final thoughts, Rich, or should we take some questions?
Oh, several of you have put questions in the Q&A, and I've tried to answer some of them. And if my answer wasn't sufficient, please say so in the Q&A or ask a new question. There's two questions that I didn't answer because I thought would be good to discuss. One really relates to the last couple of slides about predetermination. The question was, how does the child's team overcome the school's team preconceived plan and their resistance? And you know, Paula talked about the legalities. I'll say as an advocate, one thing is to if you think you're seeing predetermination, call it out. say, this seems like the school team has already decided it was going to be 3 hours of service per week, and we haven't really heard a rationale for it or how you came up with that. It's just you've seemed to have decided that before the meeting. Where did that decision come from? So call it out, ask for a response. Usually if you say this feels like this was predetermined, the school team will get very defensive and try to fix that because they know that's a violation. So that it's, call it if you see it. The other is, I think a lot of times it's not predetermination, but we feel like the school team has a plan. They know what they're proposing. They're kind of all agreeing and sticking to that. There's not really any give to it. I mean, I find the best thing we can do, again, is try to be collaborative, to try and overpower, and that's too strong a word, to try and change the direction of the decision or discussion by our data. We want to present our documentation, our input from our observation, our letters from the pediatrician and the therapist. Why do we feel what they're proposing is not appropriate? And then often there is a discussion, and either the school team will come around or there'll be a compromise to those positions. And Paula, anything you want to say about that?
Yeah, I think I like your point about submitting your own data, and sometimes it's getting a little bit creative or thinking outside the box. So sometimes what we'll do is take a look at things like goals over time. I've sometimes I'll pull some old IEPs and say, if we're saying the child's not making progress and the team is saying yes they are, well, now I'm going to pull out some reading goals over the last 2 or 3 years and show the team that the child's been working on the same thing and they're not mastering it. Because sometimes I think teams get sort of stuck on this is what we're doing this year, and they're not taking that wider view. And so sometimes I do like to go back and show historically. And that might mean that I can't get, it's not going to be resolved at the meeting, but maybe I'm going to ask the team to come back because I have new information. Sometimes also I've found that you can get ahead of it. So one thing I've done more recently as we're getting ready to go into an IEP meeting is even saying to a team, look, the parent really feels that a change in placement is needed, and we would like to see these 2 or 3 programs in the county in advance of the meeting so we can talk about them, or we would like these folks to be at the meeting so that we have opportunities to talk about these different programs. So now when you're sitting down with the team, you've got the knowledge because maybe you've seen a couple programs, or you have some folks at the table that maybe the county wasn't intending to even bring, and they're bringing a different point of view, and that can help. One last point on that is, unfortunately, sometimes you can't change minds at the meeting, and there is a tendency, I find sometimes you get stuck and it's the same conversation over and over, and sometimes it does take someone saying, you know what, we're not going to resolve this here, and let's break, and then maybe you're looking at filing for mediation or taking another step.
And I'll add one last comment, which is that often disagreements are the result of not enough data. So schools saying, I was reading fine, we don't see any impact there. Parents are saying, oh my gosh, he can't read at all. Maybe we don't have a good assessment, or maybe we don't have the right kind of assessment. So let's think about that.
This is a great question, I think. Yeah, Rich, about the what counts as raw data for social emotional behavioral progress. And it brings up a point that I think we didn't really touch on, which is that if you're asking for data and you're not getting it, sometimes the question has to be, please start collecting data, right? Yes. And what would that, Rich, what would that look like for something like social emotional or behavioral data?
It could be, as the questioner suggests, it might be observational checklists that are done. There are a variety of behavior rating scales. Often when it's behavior, we ask for a functional behavioral analysis to be done, which is a formal analysis of what kind of behavior are we seeing? What are the antecedents to that behavior? What are the consequences that are now present for the behavior, both consequences that we've we're using and kind of natural consequences in the system. What's the purpose of the behavior? Why is it happening? Is it always happen when it's time for reading? Well, maybe it involves the child having a reading challenge. So really in-depth analysis, and that can lead to a behavior intervention plan that addresses those behaviors. And that's, you know, that is all data that is formal and really drives what happens for the student.
Yeah, I think the first challenge with that type of data is really identifying what the behavior is that you're measuring. So, you know, I see, like, for attention, for example, we see the consultants do a great job of this, like doing a time on task. So measuring how long the child is remaining on task. And it can be, you know, it can be a good bit amount of work to measure behavioral data, but sometimes that's what's necessary.
Paul, I think maybe one
Mhm.
last question, and we're going to have to. And there's a question about school attendance with regard to school suspension
Yeah.
actions. Can you talk a little bit about that?
Yeah. So I think what's important to acknowledge is that there are rights under the IDEA for students with special education needs who are being disciplined. So if a student has missed 10 days, the school system is required to hold what's called a manifestation determination and determine whether the child's behavior is a manifestation of their disability. Doesn't mean that the disability caused, it doesn't have to cause it, but is it a manifestation of? And I could talk for another hour and 15 minutes about just that. But if it is a manifestation, the child is supposed to be able to return to school. And so that would answer the suspension issue. If it's not, then the child can continue to be suspended, but then there are ways to appeal that. The other thing I'll just note is that if it's a manifestation of the child's disability, but the behavior, and there's like a small subset of behaviors that are like cause bodily harm. If you bring a weapon to school, there's some exclusions. The child can still be removed to an alternative location. So they are entitled to go to school. It can just be in a different location for up to 45 days. But ultimately, the school system is still responsible during that time period for providing a free, appropriate public education. So sort of takeaway is there, it shouldn't be more than 10 days. And if it is even like 2 days and then 2 more days and 2 more days, it's going to start adding up. And you can even ask for a meeting before that if it's suspension related. And if the child continues to be suspended, there's probably something else going on related to the disability.
Okay,
All
thank you,
right, I
Paul.
think we got them all in. If anyone
Yep.
has other questions, feel free to email. I don't think our emails are in the, it was our website. You can find our email, of course, on our website.
Yeah,
And
I'll give mine real quick. It's rich@wegadvocacy.com. Love to hear from you, just what you thought of today, whether it was beneficial, what more or different we could have done to better answer your questions. We would love the feedback. And
mine is, and I'm happy to give mine, Paula.Rosenstock@lawforchildren, and that's all spelled out.com. And same thing, happy to answer more questions and would love to hear from you about what you thought. And yeah, we appreciate everyone tuning in.
Okay, thank you all for being here. Bye-bye.
Bye.